Hello and welcome to Viewpoint. I'm Zakir Jacob. A significant development in the Gyanvapi case today, where a district court in Varanasi ordered that the Hindu side's petition of asking for carbon dating of the object that was found at the Wazukhana, which the Hindu side claims is a Shivling, the Muslim side claims is nothing but a fountain. Today the court has said that there does not need to be any carbon dating or, for that matter, any scientific process to investigate the date of origin of that object. Now, the Hindu side, of course, is saying that they will challenge this in a higher court, presumably the High Court in Allahabad. But short of that, carbon dating was the only scientific means to establish how old this particular object was. And if the Hindu side is not able to establish the age of that object, then there will be a lesser chance of them being able to prove their case that this was indeed a Shivling. So how does one see the order of the Varanasi district judge today? Does the Hindu side still have elbow room for an appeal and try and reverse this decision? And was the judge simply trying to put an end to this controversy, a full stop to this controversy, by taking the position that he cannot order carbon dating of this fountain or Shivling, call it what you want, because it would go against the Supreme Court's order, which is to preserve the monument as is?
The twists and turns continue in the Gyanvapi case. Now the Varanasi district court has rejected the Hindu side's demand for carbon dating of the Shivling found inside the mosque complex. The court said any survey like a carbon dating will be in violation of Supreme Court's order of sealing of the Wazukhana where the Shivling was found. The court also said that any harm to the structure will violate the top court's order to protect the Shivling, and that any harm to the Shivling will also hurt religious sentiments and lessen chances of a resolution to the legal dispute.
इस ऑर्डर के अगेंस्ट हम सुप्रीम कोर्ट जाएंगे, इस ऑर्डर को हम सुप्रीम कोर्ट में चुनौती देंगे, ये ऑर्डर अगेंस्ट द रिकॉर्ड है.
The Shivling was found during a video survey carried out in the Gyanvapi Mosque complex on the orders of a lower court, in response to a petition filed by 5 Hindu women who wanted to pray at a shrine inside the mosque. The Muslim side maintains that the object that is being called a Shivling is actually a fountain used for purification rituals. The Hindu petitioners had requested a scientific investigation, including carbon dating, to establish the age of the Shivling.
Welcome the judgment of the civil court regarding the carbon dating issue of the Shivling. The Honorable Supreme Court has ordered that the whole of the Wazukhana must be sealed. How can any activity or carbon dating can be done?
Last month, the Varanasi District Court had ruled that the suit filed by the Hindu side is maintainable and that the Places of Worship Act does not bar from the suit being admitted. So what will today's verdict mean for this disputed religious structure?
All right, I want to first go across to my colleague Pranshu Mishra, who's joining us live from Varanasi. You've gone through the detailed order of this single judge, the district judge of Varanasi. What is the rationale behind not allowing carbon dating? Is the judge going too technical into the order of the Supreme Court that the Wazukhana has to be sealed and there should be no distortion or disruption to the Wazukhana? But how does that take away from the carbon dating plea which the Hindu side had asked for?
Well, Zaka, see, it's a 5-page order, and the Hindu side, and we all have been talking about the fact that how the court has observed that this entire area was sealed by the Supreme Court order dated 16th of May this year, and therefore the court says that, any order at this stage will be actually meaning the interference into the Supreme Court's order of the status quo of the sealing of that area. But there's also another very important mention which the district judge makes. District judge clearly says that, all these demands of ASI probe, carbon dating, the court doesn't feel that this will be actually helpful in addressing the original petition or the original request that was made in the suit. Now, the original request was simply of the 5 Hindu women litigants seeking a right of daily worship of Ma Shringar Gauri. And then we saw that how this case actually meandered its way to different issues, and the focus came on the issue of that disputed structure, which the Hindu side claims is a Shivling and the Muslim side says is a fountain. The present application which was being disposed by the court today was about determining the exact nature of the Shivling, and therefore the court in a very important state observation also said that all these demands are not going to be helpful as far as the issue of deciding the original suit is concerned, the original suit of Ma Shringar Gauri is concerned. And I think therefore by this order the court has also tried to bring back the focus on the original issue before the court, and that original issue is not about the Shivling but about deciding that whether the 5 Hindu women litigants have a right of daily worship of Shringar Gauri or not.
In fact, we'll be speaking to one of those original 5 petitioners who moved the court for allowing prayers across the year. Right now, prayers are offered on one day of the year. But we'll leave it at that, Pranshu Mishra, for joining us. Let me now open this up to our guests. Dr. Geeta Bhatt, academician, joining us. Ashwini Dubey of the Supreme Court will be joining us as well. Muzakir Zama Khan is a lawyer with the Muslim side. Tausif Ahmed Khan, advocate and political analyst. And Manju Vyas, like I said, is one of the original petitioners, so she'll be joining us. Geeta Bhatt, let me start with you, ma'am, first. Because essentially what the court is saying is, and the court is going by the letter and the spirit of the Supreme Court judgment, that nothing should happen to the Wazu Khana. It should be a sealed area. There should be no either structural or temporal changes to that area. So the court is saying, how can you possibly expect carbon dating? Because this object that's been discovered there, whether it's a Shivling or a fountain, is also part of the Wazu Khana complex.
Yeah, Zakar, you see, with due respect to the judgment that has been given in the Gyanvapi case, you see, we also have to look into the fact that the leeway that has been taken by the judge and by the court is that the original petition which was filed was actually regarding the plea of 5 women who had requested for the Gauri Shankar, allowed to be doing the praying in the Gauri Shankar temple. But when later on, when this plea was added that the carbon dating of the Shivling should be allowed, so this leeway has been taken. However, the fact remains that there could always be a separate petition which could be added, and in which this particular prayer could be put forth. Okay. And the fact remains that in the court of law, it is the evidence and the facts which are going to stand. So keeping that in mind, and carbon dating is a very scientific method which in archaeology is used to find out the exact date of that particular object. So there is no harm in doing so, and in nowhere in the Supreme Court order it has been said that there cannot be a carbon date. You have to keep it protected, but that does not mean that you cannot find out the age of that.
So let me ask Ashwini Dubey, Supreme Court advocate. The original petitioners, the 5 petitioners, the women who moved the court, were essentially asking for one basic plea, which is that they be allowed to pray at Mata Shringar Gauri for all 365 days of the year, not just one day in a year. The fact that the Hindu side, and of course a lot of advocates are arguing for the Hindu side, the fact that they changed their position from that, which the original petitioners had, to doing this carbon dating on this structure that's been found, was that a mistake? Because as the judge said in his judgment too, you can do all the carbon dating in the world, but that's not going to make a material difference to the original petition moved by the 5 petitioners, the 5 women.
Yes, thank you, Zaka, for having me here. See, the order passed by the district judge's appealable order, that is subject to judicial review. Now, second, the original petition was that these 5 devotees have a right, pre-existing right, which was existing prior to 1993, when by order of an executive order, by virtue of an executive order, then state government took over that right, that they used to perform Mata Shringar Gauri's puja every day. So this position is clear. And now the second prayer is that any visible or invisible god, goddess found within the municipal limit 5180 or something plot number, which includes the entire plot number, that they should be permitted to perform puja. By virtue of the court commissioner's order, it was found that Lord Shivling was found there and Shivling was protected by virtue of Supreme Court order. Now, moving an application does not mean that they are changing the essential character of the case. Why? There is a reason behind that. Because the appointing the commission is well within the domain of the civil judge. 2, to ascertain the age of that Shivling which was found there, because prayer B is there, visible and invisible, God and Goddess, including Mata Shringar Gauri and Shivji, which will be found there during the this commission. Third, so far as this carbon dating is concerned, that will ascertain the age of the Shivling which is found there, because that is the only
No, but that
method.
has not been allowed by the court today. So how are you going to ascertain? How are you going to ascertain the age then? And the age is critical to prove that this is indeed a Shivling and not a fountain, as the Muslim side claims. So now that the court has rejected that, how are you going to go about this?
In Deen Muhammad's case, which is one of the main case referred in the cases filed by the 5 devotees, it has been categorically stated inside the body of the case that in 1936, when Deen Muhammad instituted case against then state of India, is stating that look, this belongs to the Gyanvapi Masjid, where the statement of 6 or 7 Hindus and priests were recorded. In that statement, it was found that 1669 or 1659, that was invaded. Before that, the temple exists. That has been categorically referred in this court. So it is not that they have not
Dubeji, you are missing the point. The point is, like I said, the original petition was for worship throughout the year. That got changed. Secondly, without having carbon dating or any other scientific investigation, how are you going to prove the age of the object that was recovered at the Wazukhana? Because without proving the age, you're not going to be able to prove that this was a Shivling and not a fountain, as the Muslim side claims. But let me ask Muzakir Zama Khan, who is a lawyer with the Muslim side, just because the district judge has not allowed carbon dating, A, as Mr. Dubey said, it's an appealable order, they will definitely go to the High Court, and B, the judge in this case, in my humble opinion, seems to have taken the Supreme Court's order of protecting the Wazukhana very, very literally. It doesn't mean that nothing can happen at the Wazukhana. It doesn't mean that there can't be a scientific probe in objects and structures found inside the Wazukhana.
Yeah, thank you, Mr. Jacob. The today's judgment clearly said that Supreme Court protected the site. That means the junior judge is not having any power to intervene into the site, and that's clear from the words of the judgment of the junior judge. And the first point you are talking about is that who is having the right to declare the age of the site? Yeah, by which way we are going to declare the age of the site? So I don't think that in this particular case there is a need to declare the site, the age of the site. What is the need of that? For what purpose they are seeking the age of the site? I am not getting their point, and that's why the plea.
No, not the age of the site. The contention of the Muslim side, the Hindu side, is that the Shivling was discovered inside the Wazukhana, and to establish that this Shivling predated the existence or the coming up of the structure of the mosque, then the only way you can prove that is by carbon dating or any other scientific method.
Even though it is protected by the 1991 Act, then what?
No. You go back to the previous order of the court. It did not. It said very clearly, 1991 Act does not bar a petition being moved. It very clearly said Order 7, Rule 11 will not apply. You know that. That's what was said in the last order. Of course it is sub judice.
None of the order till date is final order. Still the matter is prejudice.
Yes.
So let the final judgment come, then we will decide.
Okay. Let me also go across to Sita Sahu. She's one of the 5 women who moved the petition. The original petition was to worship. Sita ji, ये बताइए, आपका जो पहला मुकदमा जो था, आपका प्ली जो था, ये सिर्फ यही था कि आप साल भर माता श्रृंगार गौरी का पूजा और दर्शन करें, यही था आपका पिटिशन. इसमें से ये कार्बन डेटिंग, शिवलिंग, ये आपका पूरा पिटिशन कब बदला और कैसे बदला, और आपको लगता है कि ये बदलने की वजह से आज जो ऑर्डर आया है वो हिंदू पक्ष के खिलाफ है?
देखिए, हिंदू पक्ष के खिलाफ नहीं है, सुप्रीम कोर्ट में हम लोग जाएंगे। वैसे पहले ही सुप्रीम कोर्ट में ये गया था कि सुप्रीम कोर्ट ने ही इसे जिला जज में भेजा था, लेकिन आज जो फैसला आया है तो हम लोग दोबारा से सुप्रीम कोर्ट में जाएंगे। और रही बात जो आप ये पूछ रहे हैं कि हम लोग का पहले श्रृंगार गौरी, तो हाँ, श्रृंगार गौरी की पूजा पाठ के लिए हम लोगों ने याचिका डाला था, लेकिन वहाँ महादेव जी भी मिले हैं और शिव के बिना शक्ति के बिना शिव और शिव के बिना शक्ति अधूरे हैं, तो हम लोग को दोनों ही चाहिए। हम लोग ने अपनी याचिका में ये डाला भी है कि वहाँ कई महादेव हैं, महादेव जी हैं, माँ गौरा पार्वती हैं, माँ श्रृंगार गौरी हैं, कार्तिकेय जी हैं, हम लोग की याचिका में लिखा हुआ है।
तो आप ये कह रहे हैं कि आपका जो पहला याचिका था, ओरिजिनल पिटिशन जो था कि आप साल भर पूजा कर सकें, दर्शन कर सकें, वो आप उसको बदल रहे हैं और आप कह रहे हैं कि अभी जो बाबा मिल गए तो उसका कार्बन डेटिंग हो, उसका कोई साइंटिफिक इन्वेस्टिगेशन हो, ताकि ये प्रूव हो जाए कि ये जो वहां पे जो स्ट्रक्चर मिला है वो शिवलिंग ही था और वो मस्जिद आने के पहले से ही वही था। ये आपका अभी नया आपका जो प्रेयर है, अभी का जो आपका याचिका है, वो ये है।
हम लोगों ने ये जब देखिए, हमारे शिवलिंग में नहीं, हम लोग को पूरा विश्वास है कि वो शिवलिंग है, लेकिन अगला पक्ष कह रहा है कि फव्वारा है, तो वो कैसे साबित होगा? जब तक उसका जांच नहीं होगा तब तक ये कैसे पता चलेगा? वो हमारे भावनाओं को आहत करते रहेंगे, हमारे शिवलिंग को फव्वारा फव्वारा कह रहे, तो जब तक जांच नहीं होगा तब तक पता कैसे चलेगा? और हम लोगों ने अपने बात में ये रखा भी, हम लोग ने याचिका में रखा कि शिवलिंग को कोई भी उसमें कोई छेड़छाड़ किए बिना, कोई उससे क्षति पहुंचाए बिना उसका जांच हो।
नहीं, वो कैसा होगा? नहीं, वही तो आज जज ने भी कहा उनके ऑर्डर में कि बिना उसको कोई छेद पहुंचाते हुए कैसे आप इन्वेस्टिगेशन करेंगे? वो तो पॉसिबल ही नहीं है जज साहब के ऑर्डर के मुताबिक। तो इसीलिए उन्होंने खारिज कर दिया आपका हिंदू पक्ष का जो प्ली था।
इसकी बात नहीं है, जज ने ये कहा है कि ये आपका सुप्रीम कोर्ट में गया था और सुप्रीम कोर्ट ने ये वहाँ पे रोक लगाई हुई है, तो आप सुप्रीम कोर्ट मैं कैसे इसका जजमेंट दे सकता हूँ, जो कि ये होना चाहिए था। हालांकि पक्ष में हम लोग के आज नहीं आ पाया है, लेकिन हम लोग सुप्रीम कोर्ट जाएंगे, क्योंकि सुप्रीम कोर्ट में पहले भी हम लोग जा चुके हैं और सुप्रीम कोर्ट ने ही इसे जिला जज में भेजा था, लेकिन जिला जज ने शायद उस बात को गौर नहीं किया।
So Tawseef Ahmed Khan, basically what Sita Sahu is saying is that today's judgment, the judge has refused the Hindu side's plea on a technicality, and the technicality is that the Supreme Court had ordered for the protection of this Wazukhana. Tomorrow, if the Hindu side goes to the Supreme Court and the Supreme Court removes that technicality, then we are back to square one. Then the judge is free to order carbon dating or any other scientific investigation to prove, or to find out, to probe rather, how old this structure is, or this object that was found there, which the Hindu side is claiming is a Shivling and the Muslim side is claiming is a fountain. So it's a technicality.
You see, Zaka, law cannot be seen with a technical lens. You have to take a holistic approach. The current issue is very contentious. You see, on one side, we have the act which bars changing the nature of any religious site which is standing as it is from 1947 after the independence. And on the other side, we have the Supreme Court Babri judgment that was delivered by the Supreme Court, which records this fact and which assures that this act, the Places of Worship Act, is a guarantee that going forward no further religious structures nature would be changed. Now, in this backdrop, the question that court considers is that can the court, by judicial process, create facts on the ground to determine the nature of the Gyanvapi Mosque so that it can be changed? So
no. One second, Tawseef. One clarification. It's not the court's job to change the nature of the place of worship. What the court was asked of by the Hindu side was, can you order an investigation, whether it's carbon dating or any other investigation, to find out how old this particular structure is? That's all they've asked for. Now that Again,
no.
the courts are not experts in this. They'll have to go back to archaeologists. They'll have to go back to scientists to find out how old this structure is.
You see, court, there comes a time after certain facts are created on the ground, then there will come a time where court will say, oh, I am sorry, I can't do anything because a certain incident has happened. Like in Babri Masjid case, had the mosque been standing there, then we all know the judgment would have been different. The court accepted that since the masjid has been demolished, the Babri Mosque was demolished, court had no other alternative but to hand the land to the Hindu side and awarded an alternate site.
Okay.
Here, court is trying to preempt. Like the law gives us, law is very clear that we have to preempt any untoward incident from happening. Like illegal ex-party order was passed, after which the Wazu Khana was sealed. Even though court has allowed the Muslim side to continue with the namaz and continue with the Wazu.
Yeah.
Now, today the very technical question is, can carbon dating determine, is relevant to examine the stone?
No. Which is why I believe the Hindu side had also remedied their petition from just carbon dating to quote unquote any other scientific investigation to know the age of the object that was found there. But let me go back to Geeta Bhatt. The point, Geeta Bhatt, is I think Sita Sahu did not call it a setback. Of course, you can appeal today's order. But the reason why today's order came about is because there was a shifting of the goalposts. There was shifting of the petition. The petition originally was for plea to worship 365 days in a year as opposed to just one day. And that then got construed into, the structure that was found, and the Hindu side claiming it's a Shivling, the Muslim side claiming it's a fountain. There was no need for that.
Well, you see, what developed during when the video recording was done and when they entered into the premises of the Gyanvapi structure, at that time it was discovered that this, Shivling is over there, and which the Anjuman committee is disputing. So, because of this, and it was definitely a revelation, it was, a lot of people were not knowing about it, although those who have been living, in that area and used to visit pre-1991, when there were no such restrictions, people used to go inside and they all knew that this existed there in the, on the walls, you can see the different gods and goddesses which have been carved out. It is only post-1991 that these restrictions came into play. So, now the fact is that once any scientific method is used to determine the age of the Shivling, Zakaji, I am very sure that the findings will very clearly state the premises. Not only this, there are various, underground rooms over there where there are various such artifacts. One can find out that exactly to which particular era they were built. And also, Deen Muhammad's case was...
No. One second. I think we're confusing two facts. I think we're confusing two facts. One is, if you were to... And you're a historian, ma'am. So, you go back and look at the history books from the 16th century, the 15th century. It is a very clear recorded fact of history that a temple used to exist there at the Gyanvapi site. That was destroyed by Aurangzeb, and Aurangzeb put up a mosque in place of that site. Nobody is disputing that. No, nobody is disputing that.
Right.
What has happened subsequently in the modern era is after Babri Masjid, there was this Places of Worship Act which said that the character of any religious institution as it stood in 1947 on 15th August should not be changed. Now, if you want to change that, and admittedly, if the petitioners were to be given access to pray every day, 365 days of the year, then you're changing the nature of that particular place of worship, then by all means go ahead and amend that act. That is the point, Ashwini Dubeji. Because, which is why I keep going back. The original petition was for prayer throughout the year. Whether it is a Shivling, whether it is a fountain, is immaterial to the original prayer.
Jacob bhai, give me 50 seconds and let me elaborate in your point of view. First, the Places of Worship Act will apply if there will be an attempt to change the religious character of a place. Two, Places of Worship Act and the Ayodhya judgment is concerned, Ayodhya judgment does not bar from asking to restore a pre-existing right which was taken away by virtue of an executive order in 1993. That is the daily puja which was being offered. This is an admitted fact. Three, so far as the ascertaining the age of a object, I do not say it's a shivling. To ascertain the object which the Muslim side is saying that's the fawara, Hindu side is saying no, it's a shivling. The only way out where court will reach to the conclusion, because there was pre-existing right to perform the puja at the same place. That is the carbon dating. But carbon dating issue is closed by the trial court. That has to be looked into by the civil court or appellate court. Its own wisdom. I'm not disputing that. Third point which you are saying, that the prayer A is Article 25 of the Constitution of India, right to propagate, profess, preach. Prayer B is that anything, if it is found during the hearing of this case in visible and invisible form, that should be protected. That's exactly the prayer B say, and the state government and the district authorities should be directed to protect it. Prayer C is that in the performance of the daily puja, there should not be any obstruction, and the state government should be directed to protect our life and liberty. These are the prayers. And the court is there. Yes, Jacob.
Muzakir Zama Khan, I'll give you the final word. So again, I keep going back to it because I think today's order is based on the technicality that the Supreme Court had said, seal the area of the Wazukhana. If the Supreme Court in its wisdom were to relook at that technicality, then this order will get reversed very soon.
No, Mr. Jacob, the technicalities is not about the only within the domain of Supreme Court judgment. The technicality is also today's judgment is also based on a point that what is the fruitful result which affect the proceeding if the age of the site was declared by that scientific method. What is the purpose of that procedure, or it is only a delay tactic, I think. To delay the matter, to politicize the matter. The petition was changed to politicize the matter, took this matter until 2024 to fight the matter on the basis of this judgment and this orders and all that. That's all. According to me, it's a politicization. So
you are saying that this is a political matter. It's less to do with faith, less to do with legal issues. We'll see how the story plays out. Obviously, the Hindu side will challenge this in the High Court and perhaps even knock the doors of the Supreme Court, because the judge today, the district judge, very clearly and explicitly stating in his judgment that since the Supreme Court had asked for this area to be sealed, any form of scientific investigation on any object found there, whether it's a shivling or a fountain, call it what you want, that will then be violative of the Supreme Court's order. I want to thank our guests, and I'm going to go to this piece of breaking news that's coming in. A court in Delhi now has framed charges against former Aam Aadmi Party councillor Tahir Hussain, as well as 5 others in a case relating to the 2020 Delhi riots. The court has noted that the accused persons, including Tahir Hussain, had entered into a conspiracy to kill Hindus. Remember, the Aam Aadmi Party had distanced itself from Tahir Hussain, but now a court has said that charges can be framed against the former Aam Aadmi Party councillor Tahir Hussain, as well as 5 others in a case relating to the 2020 Delhi riots. Remember, the Delhi police had raided his home right after he was taken into custody, and they had discovered tons of weapons, Molotov cocktails and other country-made weapons in his premises. Let me go across to Ananya, who has more details on this. Walk us through what else the court has said while saying that you can go ahead and frame charges against Tahir Hussain.
Well, in fact, Zaka, they have already framed charges under sections of attempt to murder, rioting, unlawful assembly. And this is the Delhi's Karkarduma court, which has in fact framed charges against Tahir Hussain and 5 other people into a case relating to the 2020 Delhi riots. In fact, the court, in its observations, clearly noted that statement of witnesses and the evidence record clearly suggests that there was a conspiracy to go and kill Hindus. Is a very, very clear observation that has been made by the court. In fact, it has also been shown that the indiscriminate firing completely shows that the accused person wanted to kill Hindus. The intention was to kill Hindus in that particular area when riots had broken down in the northeast district of the national capital in February 2020, post the central government actually brought in the anti-CAA bill. Remember that various protests had broken out and violence had broken out in specifically in the northeast area of the national capital. This is the FIR 91 and 92, in which charges have been framed not only against Tahir Hussain but 5 other people. But remember that Tahir Hussain's name is being said as the kingpin of this particular riot that had happened in the national capital, and in various court orders he has been referred to as a kingpin into this particular case. In fact, the charge sheets too entail down his role into this particular case. But now the court has now framed charges against Tahir Hussain under the charges of attempt to murder.
Ananya, we'll have to leave it at that. We're completely out of time. Ananya Bhatnagar there giving out the details of the court giving the go-ahead for framing of charges against Tahir Hussain. In a moment, Akanksha will be joining you with the biggest exclusive.